All right, guys, welcome to Justice is a Process. And my name is Steve, and we are finishing up our coverage of the Lori Ann Phillips trial. We have a verdict. We had closing arguments today. We had a jam-packed day. I was on the road today. I wasn't able to get a live going before the verdict, but we're going to do some verdict coverage. We're going to break down closing arguments, but we're going to start out with the verdict. So we have a verdict here. Jury came back, deliberated a little over 4 hours before the verdict came down. Let's check out the verdict to kick things off. Here we go.
Give the verdict to Terry.
Here we go.
State of Wisconsin versus Lori Phillips, La Crosse County case number 20 CF 364. Verdict. We, the jury, find the defendant, Lori Phillips, not guilty. Signed by the juror foreperson, dated this 10th day of November.
There you have it, guys. Not guilty. Like I said, the jury deliberated for 4 hours and found her not guilty. She was freed and adjudicated guilty and released of the judge actually mentioned that she wasn't even released on a bond. I guess it must have been a signature bond, but there was no money to release back to her or anything like that, and she was free to go from the courtroom. So we're going to talk about it. We're going to get down to business here. The day started out with the finish of the direct examination of Lori Phillips. Now, as you know, if you watched my video yesterday, I was quite critical of the attorney having put her on the stand. I felt like it was a risk, and I felt like it's one of the reasons why the jury spent 4 hours. I think that was probably 3 hours too long in considering, because the state fell well short of its burden in this case. And I think that, because she testified, I think some of these jurors, there were some questions back there. I think there was probably a couple of people that had to be convinced that she didn't hit him, even though that's not really, it could have they could have had the whole jury. The defense should have had it should have been back 30, 40 minutes and they were, boom, going home. But unfortunately, they got into the weeds a little bit. Luckily, she was found not guilty in the end, which is the correct verdict. But we're going to get into some of the things here, some of the concerns I had coming into this. So she begins the day testifying on the stand, and her attorney finishes up direct examination, to which let's see here. We'll show a little bit of the direct examination. Let's jump in here and pick it up right here.
Out of the house that you were walking just towards the garage to see whether or not the Subaru was there.
Correct.
And Lori, did you appear to be upset or visibly shaken in that particular clip?
No.
All right. If we could get clip number 2 ready to go, please. All right. So, Lori, did you make it all the way to the garage when you went out looking for Mark?
No.
Why not?
Because I saw my husband out of the corner of my eye.
How did you react to that?
I freaked out and I ran straight to him.
Okay. I'm going to play clip number 2 at full volume, please. Lori, what were we hearing in that clip?
Now, guys, in my opinion, that should have been played in closing arguments in culmination with reminding the jury of the fact that the responding officer, the officer that responded to the call, that officer testified that he believed Lori Phillips was showing genuine emotion and did not appear to be someone who was manufacturing emotion or wasn't someone who had just discovered a loved one had a very bad accident. That alone, as I said 3 days ago, was the entire case. Because if the jury, well, if you believe that officer was credible and the state did not present anything to the contrary that the officer wasn't, if you believe that officer was credible, the case ended with that officer's testimony. Why? Because one of the elements was that she had to have known that that her actions caused injury to him at the time it happened. In other words, she had to know that what she was doing was reckless and put Mark in danger and injured him. And essentially, everything that happens afterwards would have had to have then been a cover up of that act. When she leaves, she goes to the hotel. And then when she shows up and she's there in the yard, she's would have to be believed that she was acting in that video and to the officer when the officer arrived. The best witness to that is that officer who gets to come upon. Remember, in the Murdoch trial, one of the first things they said was they felt that he was acting, and officers on the scene were immediately suspicious. In this case, they were not. In fact, he puts it in his report. She seemed genuine. He saw nothing in the report indicated that he was suspicious of her behavior or her actions or anything like that. Case closed right there. Closing argument should have been real simple. Listen, start with your weakest element. Start with the weakest one of these three things, because there's three elements you got to prove, and the state had to prove beyond a reasonable doubt. If any of those fall short, it's not guilty. So therefore, you don't have to go debate the other ones. Maybe you agree that 2 out of 3 are met, but if one of them isn't, case closed. It's not guilty. We're going home. And that's what the defense should have done, was went in and said, listen, go back and look at this element. Focus on this element. Focus your debate on this. Look and see, does the evidence line up for these three elements? And if they don't, if even one goes, you don't have to debate anything else. You don't have to debate, any of it. Domestic violence should have only gone to the state of mind. It was only a state of mind issue for Lori Phillips. In other words, she's there at the house. He's coming up. She's just experienced all these things. Her state of mind is such that she doesn't want to be attacked anymore. She's distracted by the domestic violence issue. She's distracted by the potential threat that he's going to put hands on her again, that he's going to harm her. And as a result, because of that, in culmination with the adrenaline of the situation and the fear of the situation, and it's dark, it's a cold night, it's a winter night, and she's also got other obstacles that are in the driveway, and she says, I'm getting the heck out of here. So she goes, and boom, it's very easy that in that moment she didn't realize that she hit him. And it's also very likely that it was not that the way this occurred, since there was no evidence, and that was another thing that the defense should have hammered home, instead of spending all the time talking about domestic violence like this was some sort of self-defense case, is the fact that there was no evidence that wheel went over Mark. There was evidence he was on the undercarriage. There was evidence that he could have potentially been under the car somehow, maybe by slipping and falling, but there was zero evidence that wheel had gone over him, that there was blood or bodily fluid or any indication that a wheel went over him, which would indicate that maybe he was between the wheel and the snow embankment, and that's how he got the compression fractures. That's how the 9 ribs get broke. And unfortunately, he ends up in that snowbank. She ends up down the street. She's thinking, hey, I just got away from him. He's going to be coming after me. He's going to be going to the bar. She's dealing with all the emotions of a fight and that they're breaking up, never knowing that he's laying there in a driveway dying. She comes back home. It's dark. It's snowing. She's looking towards the house. She's not looking at the snowbank. She's looking to see if he's up, if there's movement in the house, if she sees any sign of that, because she's worried. She doesn't want to come home and get in the fight. She's focusing on leaving and coming in. Of course, she doesn't see him. So she goes in the house, has a restless, sleepless night, finally gets up and says, I haven't heard from him. I'm going to go check on him. I'm going to go see. He's not down, and realizes he's not down. He's not in the master bedroom. He's not down in the couch. And heads outside it, and you see the video. It's all genuine. This case should have never, ever been prosecuted, but it was. But anyways, let's get into some other interesting things. This judge was a trip. I couldn't believe some of the things this judge did. But let's move on. We're going to go into the cross-examination here. Give me a moment.
Yeah, sustain.
Okay. So something clicked in Mr. Phillips. That's when he became the worst you've ever seen him.
When he clicked, it was, wait a minute, if you're leaving, I want to get my stuff. That's when it went from coming out to punch whatever he was going to punch, whether it be the window or myself, and then realize I was absolutely leaving. I think it was a stall method on his part that said, wait a minute, I want all of my stuff out of the truck.
So it's while he's going through the stuff in the truck. That is the worst you've ever seen him.
The most angry I've ever seen him is when the phone fell onto the ground.
Okay. And that's when he goes around the truck.
That is correct.
Okay. And we've heard
Now, I bring this clip up to you because this is where I started to get a little concerned, because she's up there talking about he's the worst I've ever seen him. Now, the prosecutor is attempting to trip her up, because what he's saying is he's essentially trying to paint her as uncredible and that she's floating a story, because what he's pointing out is isn't it your testimony that you were choked, physically beaten by him? And you're saying a look is the worst he's ever seen. So the question is, why are you trying to, if you claim you didn't know that he got hurt, why are you trying to say this is the worst? And one of the statements, she made kind of a spontaneous utterance while she was on the stand that this was the worst. And then that ended up setting off this exchange that you just saw for probably about 15 minutes, where he keeps circling this around because she's on the stand. And that's the danger of putting her on the stand. Remember, prior to her going on the witness stand, when she testified to pretty much everything she told the cop, she had nobody who had come and really interrogated her in a hard fashion. She put her statement forward, compared a statement to the facts. You really didn't need her on the stand, and you didn't need all this domestic violence stuff going on. Perhaps maybe you needed to you put one of the friends on to verify what the night and the evening had been about. But as you're going to see, the prosecutor begins circling in and begins approaching this, and they eventually made the argument that she was in a state of mind. Her state of mind at the time is she's angry, that she's getting yelled at, berated. She's getting told that he's gonna cheat on her, basically getting her anger up, so that at the moment that she decides to drive off, they're gonna say, hey, he starts to pop around the car, and she's pissed off, and she just boom, floors it right into him and runs him over. And again, this is why there was 4 hours of debate in that jury room, because she testified, because it gave the opening, and the prosecutor makes the case in the closing argument to say, hey, so she had to have felt it. If you ran over an animal, if you run over a speed bump, you know when you're going over something. And again, it could have gone the other way here. You could have got 12 jurors that resonated with and said, yeah, you're right, there's no way. If you believe the state's version of events, that because of the fibers being on the undercarriage, because he's got 9 broken ribs, it's all on the left side, that she had to have run over him, and you believe that she would have had to have felt that, and then she leaves, that everything she does after that, from the hotel to the coming home and going out and finding the body and then acting upset, you believe that she's staging everything, looking at the cameras. That's how they tried to color it. But again, if you don't put her on the stand, you never have the state of mind stuff. You only have the the statement that she made, which she really didn't need to explain, but you don't have the ability to cross-examine her and question her deeply about exactly what her state of mind was, and then have her make a spontaneous utterance like, oh, the worst was yet to come. And it's like, what? Well, what do you mean? You didn't know that. You didn't know anything was coming. How do you know the worst was yet to come? And then you end up in this exchange that they ended up in. So this is textbook why you don't put a defendant on the stand necessarily, although I don't think this attorney is going to learn from that, because I think he's going to think, hey, I put her on the stand and it worked out, even though I don't think it worked out very well. But this judge, oh man, let me try to find the clip here where, let's see if this is it right here. This judge was unbelievable in this case. I have never seen a judge. I mean, it was quite crazy. I think this is it right here. We're going to find out.
All right, there was a earlier sidebar, which I dismissed immediately, which was Attorney Scamp accused Mr. Zacher of nodding his head and gesturing towards the defendant. Is that correct?
Yes.
And I didn't even give Mr. Zacher an opportunity to respond. I didn't see it. I didn't, Mr. Zacher, were you doing that at all?
No, I was not, Judge. This is just the way that I sit.
Right. Since then, I've been watching Attorney Scamp staring at Mr. Zacher, trying to note other things. Have you seen more things since? Have you written down any indication that he's nodding or indicating anything?
I'm watching for that.
Right. So much so that it's distracting. I think Mr. Zacher is very conscious of it, and I'm very conscious of it. I have to pay attention to the trial. Act professional. Stop doing this. Whatever it is, stop doing this. Stop staring at him, because he needs to do his job. And I don't know if you're nodding or not, but do not nod or anything of that sort. If I've never seen this level of response. I mean, I don't. If you continue to do it, it distracts the trial, and we will be here for a long time because they'll keep on taking the jury out. So you have a choice. One, trust that you're both professionals and act like professionals. Or two, we're going to keep on stopping the trial.
I just would like the record to know that because you did dismiss my concerns, which were brought to me by people in the gallery through a message, and I started watching, I sidebarred after I saw it happening more than once.
What do you think he did? What exactly did you think he did?
And Mr. Burdick would ask a question, would look at Lori and like slightly shake his head yes, slightly shake his head no. Sometimes he wouldn't, but there were times that he did. And it would look to me clearly that he was coaching her. And I did have.
Let me ask Ms. Phillips. Ms. Phillips, did you see him shaking his head yes or no?
No, I was paying attention to the person that was talking to me.
Did that influence any of your questions?
Not at all.
All right. Ladies and gentlemen, I will clear the gallery if I need to. So you have a choice. One, do not react. Do not text in this courtroom. Do not text in this courtroom. Put your phones away. I do not, if I hear there's more texting or any other indication, I will take your phone. This is a courtroom. Demeanor is you stay calm. I'm frustrated with this because you're delaying the trial. I don't believe anything.
He doesn't want this trial
inappropriate was
delayed.
done. We're going to move on with the
He's been
trial.
trying to get it done.
Of course I'm not. That's why I asked the jury to be removed. I think the outburst by the district attorney's office was somewhat inappropriate because it was so loud in front of the jury. I'm not going to give an instruction because I don't think it was loud enough. but it has to calm down, and it has to calm down now. This is a very serious trial with high emotions, and it must calm down now. Do both parties understand that?
Yes, Your Honor.
Yes, Your Honor.
Understand. All right, let's bring the jury back.
Your Honor, I'm sorry, can I use the restroom?
And we have another restroom break. Unbelievable, man. I love it when he goes off that. I mean, look, the guy is clearly, he must have been a defense attorney because he's clearly very pro-defense and seems to have a defense-minded approach and seems to be very hard on the state attorney's office. But I found this to be a little wacky. But hey, you know what? This judge has been a trip, but he seems to be very fixated on getting this trial done and speeding this trial through. And I think that's terrible. I really hope somebody reports that. I put a video out and a short about it, and I really hope somebody reports this to the state bar or the Supreme Court of, I'm not sure who presides over judges. I know West Virginia, it's Supreme Court of West Virginia. But somebody needs to talk to this judge and let him know, listen, if you're weighing getting the trial finished or making sure that all of the evidence that needs to be presented is presented so that not just the defendant, but the victim who's being represented by the state is getting their due process. He's violating the due process rights of the victim in that sense when he's limiting the state, and he's violating the due process rights of the defense when he's limiting the defense. And somebody needs to step up. These guys are not willing to do it. They seem to be scared of him. He seems to be willing to, go after people in the public forum. Sometimes you got to take a contempt. Sometimes you got to take a C just to make an issue. I know my dad used to do that, and he talked about the fact that sometimes with these judges, when they get out of control, you got to step up, and then you've got to be willing to press that issue so they go on record against you. And these prosecutors should have done that to protect their case, because the thing is, they don't get to appeal it. They don't get another chance at this. So if they've had to cut witnesses out and limit testimony, and then they end up, the defendant ends up getting acquitted, was it because, who knows? If they would have put those extra witnesses on, maybe we have a whole different situation. Maybe there was evidence that there was something on the wheel, but they just thought, well, we don't need it because this judge wants the case done in a certain period of time to fit his schedule. That is ridiculous. And if I was the victim's family, and I strongly felt that this was the wrong verdict, and I felt like this judge's demeanor and behavior and attitude had caused the case for my family member to be limited, as far as going, against the person that was responsible for their death. They need to go file a complaint. They need to get a lawyer. They need to look into this, get the transcript called up. Heck, it's right on the internet. But this was crazy. It was outrageous. It shows bias, and I couldn't believe it. But this guy, I've looked into, researched the judge, and I know he's got issues out there, other issues. He's got other people that are upset. But man, I'll tell you, that was shocking. But anyways, we get through. We're gonna watch a little bit of the closing arguments. We're not gonna watch all of them. We'll watch a little bit of the closing argument here of the state. And here we go. We'll cue this up.
Of how she drove by him, that she didn't see him. And here's the picture here. This is Exhibit 20, I believe. If Miss Phillips had come into the right, gotten onto County Road W, and then goes up the driveway, this is light, granted, but that's Mr. Phillips' body right there. With the white sheet that the ME or Tri-State put on him, Mr. Phillips was wearing dark colors at the time. Mr. Phillips was at night. Previously, that affects visibility, but this is the straight on shot. And you can see him even with the white on white, and that this, when Miss Phillips would have arrived in the driveway, that this would have been 0.15 inches less snow accumulated on the side of that bank. The ambient light here she talked about how the dining room light was coming through in terms of her testimony, these big windows on the side. And she has headlights, and we saw her headlights, or not her headlights, we saw Sergeant Valencia headlights, how they would have projected. So Miss Phillips pulls into the driveway, and Miss Phillips avoids the sunglasses, the same sunglasses we saw that have the glare, that have the reflection, that even if it's dark would have refracted the light back at her, these sunglasses. And and we can see the distance between that and Mr. Phillips' body up in the right corner. We can see again how it cuts here, going up to that narrow area between the man cave and the door. Has an opportunity to go to stay with the Klinskys, to go to Winona. She has an opportunity to go with her friend. She has an opportunity to have her friend's stepdad come to her. Miss Phillips has an opportunity to be safe. The hotel didn't work, but Miss Phillips has an opportunity to go somewhere. She has an opportunity to go in the truck, but she doesn't do that. She continues to check the cameras. At this point, motion sensors are still activated. She still has the ability, she's live streaming. She's looking for, in her words, comings and goings. This is the part where Miss Phillips, I guess, can't have it both ways in terms of her version of events. It's either she's scared, this is the worst experience she's ever had, this doesn't make any sense, I'm so terrified that I am unsafe and I need to focus on my safety. Or is it that I needed to get home for a reason, or is it that I wasn't concerned for my safety? Because at this point, this is about the time she goes back. She turns off the cameras. She says that that's not to disturb Mr. Phillips. She indicates that, I guess she didn't indicate this, but I'm arguing she's going back to the situation, not the situation, but she's going back to a house alone after turning down potential law enforcement help or thinking that it was a cop in the subdivision. She wasn't looking for help. The neighbor that pulled into the subdivision, she's not looking for help. Any of the time period that happened after that, not going to Onalaska, not taking an opportunity to go with the Klinskys where she would have had people to watch out for her, look over the place, call law enforcement on her behalf if necessary. She's chosen or is indicating that she's going to go back to a residence alone with Mr. Phillips, the same violent Mr. Phillips that we heard about, the same terrifying Mr. Phillips, the possessive Mr. Phillips, the drunk Mr. Phillips.
And look, this is where it gets disturbing to me because at the state attorney who's supposed to be, I'm sure, I don't know what this guy's background is. I don't know what cases he's been involved in, but I assume he's had to deal with domestic violence victims. But this is where it's like when you listen to him and you're listening to this argument, when I was listening to this earlier today, it's like he's grasping at straws. He's got nothing. He's trying to figure out his case in his closing argument and trying to make it sound, like, hey, look, she's not afraid. She wants to go back to this to this guy who's a bad look. It's clearly there's police reports, there's witnesses, there's bartenders that have seen the violence. It's undisputed that this guy was abusive to her, right? If this case would have eventually played out the way domestic violence cases play out, and she ends up dead, she ends up harmed, and he's sitting there arguing, he would have no problem arguing that Mr. Phillips was an abuser, and then he kills her, right? But she defends herself in a sense. She flees the scene. She advocates for her own safety. And here this fool is sitting here calling her foolish for leaving the scene, letting it cool down, checking her cameras, it's very clear. If she's worried about a DUI, if she thought she hit the man, do you think she wouldn't be really, really worried about, oh my God, I'm going to go to jail. Oh my God, what's going to happen? Oh my God. But you heard her saying, I was worried there was a police officer behind me, not because I had just hit somebody. It was because she was worried about getting a DUI. She's, and again, I can't believe this man doesn't have experience with domestic violence situations, but clearly this lady is not going to be at that particular moment 5 years ago in the middle of her cycle of abuse. She's not going to be sitting here looking at it as abuse. She's not going to look at it as something. She's going to look at it as, I needed to get away from him. I'm getting tired of it. She's going through, what tends to happen in these instances. She's giving the ring back. She's breaking up with him, but then she ends up going back. And in the meantime, she's in that process of they're fighting, and then she's starting to go through the, where she's rationalizing away what's happened that evening, figuring out her excuse to head back to the house. The hotel didn't work out. She couldn't get a hotel. She doesn't want to go up to her friends because, again, even though she said she's ended the relationship, she's still afraid. She still doesn't want to do the finality of, I'm going to leave and go, which really is what she's saying. If I leave and go up there, that's kind of creating a finality that she wasn't ready for. So she returns back to the house, anticipating that either A, he'll be coming back because he went out for a night of bar hopping, or B, he's already passed out because he's been drinking a lot and he's going to lay down and eventually he's going to pass out. And then he'll wake up in the morning and they will discuss the events that occurred and figure out where the relationship goes. But this guy standing here making this argument, this is why I cannot believe the jury took 4 hours to figure this out. And it's because the defense attorney, when he gets into his closing argument, well, we're going to go to the beginning of his closing argument. Let me pull this.
There was never going to be a good outcome on February 22nd. There were only two possible outcomes, and they were both bad. It was a lose-lose game that Lori Phillips was forced to play. I told you at the very beginning of this case that this is the story of an ordinary woman in an impossible situation. A case where somebody was forced to react, and she reacted the best that she could in the few seconds that she had. Lori Phillips isn't perfect, but Lori Phillips isn't a murderer. It's often been said in the legal profession that accidents happen, but crimes are committed. This is not what we call a strict liability offense. The mere fact that somebody's dead is not a crime in and of itself. The difference here is on what the mindset was leading to the fatal injuries. And as Mr. Burdick noted, the state has several elements they have to prove. They have to prove actual physical cause. They have to prove that Ms. Phillips's conduct, not Mark Phillips's, but Ms. Phillips's conduct, created a substantial and unreasonable risk of his death or great bodily harm. They've got to prove the why. Was this so unreasonable under the circumstances that it constituted criminally reckless conduct? And finally, they have to prove knowledge at the time that she knew, not should have known, but knew that she, Lori Phillips, was creating a substantial and unreasonable risk of killing her husband. Listening to the state's theory, I had one question during Mr. Burdick's closing. What is the state actually saying happened? We have this version of events of Mr. Phillips is dead and Ms. Phillips must have done it. And then in the middle, there's kind of an ellipsis of ... fill in the blanks. She must be in the wrong, ladies and gentlemen, because we don't like the fact that Mark Phillips is dead. They can't tell us that how this accident supposedly would have happened. The state can't come up here and rule out Ms. Phillips's versions of events. The state can't come up here and tell you that she was so unreasonable under the circumstances because of this rage and not the fear that she expressed repeatedly in her contemporaneous text messages to Hannah, to Adam, to her statements to Officer Lionfelder after the fact, to her statements and her testimony at trial here, ladies and gentlemen. The state can't tell you any of this because they don't know. It's the state's job to know this. It's the state's job to fill in these blanks. And effectively what they're relying on is this assumption that she must be in the wrong without feeling the need to prove exactly why that is the case. I found it offensive, ladies and gentlemen. The state came in here and said, this is how a domestic violence victim should feel. This is how she should react. Ladies and gentlemen, the state has no business telling Lori Phillips how she should react. You're not going to know how that's going to go until you're in that situation yourself. The same thing with the trauma. There is no right or wrong way to respond to the death of your spouse. People respond differently. And the state seems to be relying on this assumption that.
So again, not a bad start, right? The issue I have here is he starts getting into the domestic violence stuff. He starts making this a domestic violence situation instead of, he started out at the right moment. He talks about the elements. But what he really should have explained to the jury is that you can't, if the state fails at even one of those elements, it's done. So what he should have been doing was talking about when you get back to that jury room and you're deliberating in this case and you start your deliberations from that. If you fail at even one, stop your deliberations. It's not guilty. Stop your deliberations. It's not guilty. You don't have to figure it all out. You just have to figure out. It's really quite simple. 1, 2, and 3. Did they meet their burden on those? Go into the evidence go into why he feels they didn't. But when they get back there, let them know that they don't need to sit around and debate 2 and 3 if 1 doesn't fit. So in the spirit of not wanting to waste time, figure out where the weakest one is and start with that one. And let him suggest that this is your weakest point. Start here. Start here at the point of knowledge. Did she know? And the only way you would know that she knew is you would have to believe that she was faking the emotion you heard in that video and faking the emotion that she had when she addressed the original officer who came on the scene and believed her. You don't have to believe her. The officer believed her. You weren't there. You have to rely on the officer. You have to rely on the record. It's what's in that record that was presented by the state who put that officer on the stand and elicited that testimony and ultimately was reiterated on Crosse that, yes, he didn't see evidence that she was faking and he believed she was being genuine, that she appeared to be a genuine person expressing genuine upset over having just found her husband dead in the driveway, severely injured in the driveway. And she's trying to figure out what in the world happened. And as a police officer, as an experienced police officer, his knowledge, his impressions speak to everything. On top of that, when you're looking at the element of reckless behavior and you say, okay, well, what is the theory? The state didn't have a theory. And he points that out. That's really good. And he points out that the medical examiner, but he didn't stay on it. He should have stayed right on that point and said, listen, this is the crux of everything. That medical examiner told you that it's just as likely that the state's theory that he was run over could have happened based on the injuries he saw, as it is that something else occurred, like he fell, slid, fell down, got crushed in the embankment. Ways that he could have gotten those injuries and she would have been none the wiser, especially in an adrenaline-filled moment. And what is the evidence beyond that? Well, you got a fiber. But do you have evidence that the wheel went over him? No evidence. No evidence that a wheel went over. It ends right there. And that jury is going to go back to that jury room and go, yeah, you're right. Hold on a minute. Let's look at it. Let's look at it. That's simple. Unfortunately, he gets all caught up in wanting to make this case about a domestic violence victim, and that domestic violence caused this, and that she was in fear and she had no choice to do it. There wasn't a choice because she was just in the middle of an argument. It wasn't some grand situation. It wasn't some major thing where she felt like her life was in danger at that moment. She was in the middle of a domestic dispute that had gotten physical, and she had decided she was done with the dispute. She was done with the verbal abuse. She was done with dealing with the situation, and she was leaving. And he wanted to stop her. And she goes out, he's coming at her, and she's trying to get away because she knows she'd already been physically assaulted once in the evening. She wasn't sticking around and get physically assaulted again, especially now that they were at home. So she leaves, and somehow he ends up injuring himself in the process of trying to come to get her and stop her from leaving. And had she known it, she would have left, or she would have absolutely gone back. And that should have been the first question. Were you aware he was hurt? No. Would you have gone back? Absolutely. Would you have, and really driven that home and then said, hey, was that genuine? Was this all this business about the domestic violence and building it all up? None of that matters. None of it really matters because none of that was happening at that particular moment. I mean, it was an extension of it, but what really mattered was what they could prove at that particular moment in the state. The state has the burden to prove. But anyways, let's listen to a little bit more of the defense's closing, and then we will wrap things up here. But what an interesting case, guys. I mean, this was one that, like I said, I felt as I was watching this, within the first day or two, I felt the defense had this case won. I was surprised they even put a case on. And had they not put a case on, I think this would have been an even quicker verdict if they would have never put a case on and never had her testify. I think they made the situation harder for themselves. But anyways, let's get back in.
By Mr. Stevens, by Ms. Phillips, by the video surveillance system itself. And we can't ignore those photos of Lori's injuries the next day. And this is just one of the things that's just mind-blowing to me, that there was a description of a domestic incident leading up to this, and there was no effort to say, let's document your injuries. Let's take some pictures of this. Let's take you in to go to a forensic nurse to make sure that everything is documented and taken care of. That was left to Ms. Phillips' friends, who were shocked to see all of the bruises on her that each and every one of you saw after the fact. Bruises that corroborate her injuries, that corroborate the pain that she described in her breast. Bruises that corroborate what Lori talked about when she was forced down into that car. And where was Lori when Mark was in this condition? At the end of the evening, he's inside of a truck, slammed up against the truck, dragged in there hard enough to leave a bruise on her bicep, punching the window. And ladies and gentlemen, I disagree with the state's contention that punching a window will necessarily leave injuries that'll be noted in an autopsy, but that's neither here nor there. And she's locked in this truck, and where is he bringing her? He's bringing her back to rural Holman. Nobody's going to hear her scream for help. Nobody's there to protect her. If she called 911, ladies and gentlemen, how likely is it that she's even going to get a ringtone before Mark's already at her door? Lori is on her own at that point, and she's with Mark, who's visibly drunk. How do we know he's drunk? His blood alcohol concentration was a 0.149. Now, we don't know exactly where he was at the time of his death, but that was the blood content at the time of autopsy. That's legally drunk. That's well over the legal limit to be driving. And in this point in time, when her husband is drunk, enraged, taking her to this isolated location, he charges at her in a matter of seconds and forces her into that decision. I want you to think about that, ladies and gentlemen. How would you like to make the most important decision of your life and be given only 3 or 4 seconds to do it? For the sake of comparison, most NFL quarterbacks get more time in the pocket than Mark Phillips gave Lori that evening. And you know what? She better be right when she decides. Because if she's wrong the one way, well, now she's on trial for homicide. But if she's wrong the other way, ladies and gentlemen, we might still be here. only the title of this action wouldn't be the state of Wisconsin versus Lori Phillips. It'd be the state of Wisconsin versus Mark. And when Lori reacted, that was the very definition of instinct. Fight or flight. This wasn't a conscious thought process. This was a reaction. This is something that's ingrained in your very DNA as a basis for our survival. And the state's trying to falter for that. It's not unreasonable, ladies and gentlemen, to follow those basic human instincts. It's not unreasonable, ladies and gentlemen, to get yourself to safety. It's not unreasonable to tell anyone in that position that they need to look out for themselves first, rather than taking care to make sure that they're not doing harm to their abuser. And if you believe that one reasonable option under those circumstances was for Lori to flee her husband, then your decision's just been made very easy, because that's the very definition of reasonable doubt in this case. And the only proper verdict is not guilty. That brings us to the final prong of the state's burden here, and that's whether or not Ms. Phillips was personally aware of her conduct creating a substantial and unreasonable risk of Mark dying. And I think it's important to reiterate that this is not a burden of what should she have known. It's a burden of what she actually knew. And all of us agreed at the beginning of this case that when you're in an accident, you're not thinking about what the gradient of the tire was on the back if you're going over a snowbank, or how fast the vehicle is spinning or yawing in one direction. You're thinking about how hard your heart is pounding out of your chest. You're thinking about how you're having a near-death experience. And in a case like this, the evidence shows overwhelmingly that Lori had no idea that Mark might have been injured when she fled from him. We see this in her text messages back and forth with Ms. Klinsky. We see this in her contemporaneous remark about that faulty text message coming in about happy hour, where Lori's like, oh, Mark just texted some friends about going out for drinks, typical, or whatever the text message said. We see this in Lori's text messages to Mark, telling him that marriage may be over, that she's not going to Bismarck with him. She's not sending these text messages, ladies and gentlemen, if she has any reason to believe that her husband is on the side of the driveway dying. The same thing can be said of what she said to Ms. Klinsky. And to me, this is one of the linchpins that tells us exactly what Lori was thinking. She was still scared of him. She was still scared at the prospect of abuse, because when they offered her a safe place to stay in Winona, she said, no, Mark would freak if he found out that I went to Winona. You all heard from Lori. Mark didn't let her go there alone. She had exes there. And Lori's indication in response to that text message tells you all you need to know about whether or not she believed that Mark had been injured at that point. The same can be said for her search for a hotel and a place to stay. If Lori's intention here was to run him off the road and leave him there to die and then come back and stage a scene after the fact, then why on earth is she looking for a hotel? Why on earth is she trying to find someplace else to stay? If that were truly her intent, why not go back there and clean up the scene? The fact that she's looking for a hotel tells us that Lori's telling the truth. She didn't feel safe going back. She didn't want to go back because she had every reason to believe that her husband was drunk and furious and still there. And in that context, her Google searches also tell us a great deal about what happened. Aside from looking for a hotel, what is Lori Googling? Physical abuse. And physical abuse, quit or quote, however you want to remember that. She's Googling that, ladies and gentlemen, because she was trying to figure out exactly what happened to her. She wanted Mark to have some sense of exactly what happened to her. And that's exactly why she sent him that text with the quote from the domestic violence resource, that she wanted him to reflect on it. She figured he'd reflect on it. Think, man, I could lose my marriage over this. She wasn't sending that to somebody that she believed to be dying or dead. And the camera views of Lori turning on or arming and disarming the cameras is also consistent with that state of mind. You heard Lori's explanation. You heard she wanted to see if Mark came after her in the Subaru or if he went out to another bar. You heard that, yes, she acknowledged that she wanted to see if Mark followed through on that threat or comment to go bring some other women back to the house, which is why she's looking at all the camera feeds, including the one over the hot tub. And when she comes back, she turns it off because she doesn't want it to trigger her passed out husband, who might realize that Lori had arrived and come back for round two. The fact that she turned it back on is also consistent with the years of abuse that Lori suffered. That was something Mark expected as well. And she turns it back on at, I believe just shy of 5 a.m. in the morning when she was on and off sleeping upstairs. That's consistent with Lori's story. That's not nefarious, ladies and gentlemen. And I want to talk a little bit about the snowbank here. I told you that a picture is worth 1,000 words at the beginning of this trial. And hopefully the photos that you've seen have proven my point. But if there's anything that I want you to pay attention to with this question of whether or not Lori would have known, should have known, could have known that Mark was out there when she returned in the middle of the night at 2 a.m. in the pitch dark, it's Sergeant Valencia's squad car video. This was before she was ever placed over Mark, and we showed it to you frame by frame by frame. Mark Phillips wasn't visible in any of them. This was a circumstance where he was right there in the snowbank, under circumstances where unless you look right over 90 degrees in a direction that you're not traveling, you're going to miss him. Particularly when you hear that Ms. Phillips came up by way of West Salem, it wouldn't have been coming from the west like Sergeant Valencia, where he could see Mr. Phillips's body in the twilight. She was coming from the other direction where he wouldn't have been visible, coming up the driveway under circumstances where he was perfectly concealed in that snowbank. And we know for a fact that Mark had likely ended up in that snowbank initially after the accident, and that he had been there for almost the entire time because his body heat had melted the snowbank all the way down to the grass level. And then as he cooled, he actually refroze in that position. I think the evidence is fairly clear that Mark had been in that position from the original point. And it's entirely plausible under the circumstances here, in a truck that she's only driven a few times before, much higher vehicle, that she wouldn't look in a direction that the direction of travel would be as she happened to pull in to that portico between the house and the man cave. And in order for the state's theory to make sense, that this was an act of jealousy and Ms. Phillips knew when she was combing the cameras, hoping that something bad hadn't happened, all of this prior evidence would have to be an act. Her text messages, her responses to Hannah, physical evidence in the home, all of that would have to be a ruse concocted by somebody who, despite being accused of committing a crime of passion, would have to have an awfully good understanding of Wisconsin criminal recklessness law in order to come up with her story and come up with her version of events and fake all of these text messages and comments throughout the night. Ladies and gentlemen, the simplest explanation is usually the true one. The true explanation in this case is that Lori Phillips didn't know that Mark was injured. And in order to prove otherwise, the state would also have to prove to you that her reactions on those video surveillance systems from the home were also faked. You all saw that. If that was an act, then let's get this woman a statue. Because, ladies and gentlemen, that was the reaction of somebody who saw her husband for the first time dead on the side of the driveway. She didn't fake that. She didn't fake her panic 911 call. And she certainly didn't fake it with the 3 officers who interacted with Ms. Phillips that day. Sergeant Valencia, Investigator Lionfelder, and Deputy Stollinger, all of whom described her as extraordinarily upset. So upset she couldn't stop shaking, distraught. The reason that Lori was so distraught in those videos, in that 911 call, in front of the officers, is because she was telling the truth. She had just experienced the worst moment of her life, finding this man that she had a complicated relationship, but a man that she loved nevertheless, dead on the side of the driveway. And if that's what the evidence suggests, then ladies and gentlemen, the state can't possibly prove that she had the required knowledge at the time that she left the driveway. Knowledge that she was risking Mr. Phillips's life. So where does that leave us? I'm going to go back to the deck of cards, ladies and gentlemen. Remember, I told you that proof beyond a reasonable doubt, you're not comparing one side of the story to the other. You're comparing it to yourself. And in fact, you're comparing it to see if all of the cards are back in the deck. So is there reasonable doubt in this case? Absolutely. There's a corroborated history of physical abuse. There's Mark's behavior in the bar, captured by witnesses and videos. There's his blood alcohol concentration of 149. Dr. Reichard's agreement that this accident could have happened in a way consistent with Ms. Phillips's innocence. Mark's perfect concealment behind that snowbank. Lori's video reaction in a 911 call, the corroboration of all of Lori's movements after the fact, and her cooperation with law enforcement in providing her phone and camera login information, and that fight or flight instinct that each and every one of us can understand. And you know what? I am a true believer in our system of justice here in the United States. And that I believe that a group of 12 people selected randomly out of the voting rolls, that's how we found you're all good citizens, can come to a better conclusion than any one of us could individually. And I respect the fact that in the course of your deliberations, the 12 of you might be able to take some of these cards and put them back up on the deck. But before you reach the result that the state is asking for, they've all got to be there. And they're a long ways away from that. So the way that this works is that the state gives their closing argument, and now I'm giving my summation. And since the state does have that highest burden of proof, they get the last word. When I say thank you and sit down, that'll be the last that you hear from me during this trial. I'm confident that whatever Mr. Burdick says in rebuttal, you'll treat with the same degree of careful analysis if you've treated the rest of the evidence in this matter. So if there's any one thought or theme that I want to leave you with as you go into your deliberations, I want to bring you back to that final confrontation outside of the dive bar. Mark has Lori slammed up against the truck, and you heard her testify that she raised her voice. Stop, Mark, stop. You've done enough tonight. Hoping that the people in the parking lot will come to her rescue. Hoping that somebody would put a stop to it. Nobody did. Nobody came to her rescue at the home. Ladies and gentlemen, the 12 of you who deliberate have the power to come to her rescue 12 years after the fact. You have the power to say that what happened to Mark was awful. It was tragic, but it wasn't a homicide. Lori Phillips is not a murderer. The only proper verdict in this case is not guilty. Thank you for your time. Thank you for your attention. And thank you for your service in this case.
So, guys, like I said, he hit the points, right? He hit points. But the thing that I think he could have really honed in on and probably was something that caused the deliberations to go a little longer than what they needed to be was the idea that you only have to have reasonable doubt about one of those elements. So when you start approaching this, approach it in a way that says, okay, start out with your weakest one. Start out with this one. Start assessing this. If you find out that it's not proven beyond a reasonable doubt, stop your deliberations. They're over with, right? It's over. If that one is concluded that there is not, that there's no proof beyond a reasonable doubt, it's over. It's done. But unfortunately, he goes through all of these elements, but he doesn't tie in the fact that, or he goes through all of those pieces of reasonable doubt and says, well, this one and this one and this one and this one, but he doesn't necessarily tie it in. What he, in a case like this, the most important fact is the fact that there's three elements that all have to be proven. You miss one of two, two of two, two out of three, or all three of them aren't present, it's not guilty. Doesn't matter. Still not guilty. And that was the part that I think he, again, he got really into the weeds of wanting to portray her as if she was a individual fighting back against domestic violence. And that's not what happened in this case. This was a situation where, again, I take a little bit of umbrage with the idea that he says she had to make a decision in 3 minutes. She had less time in the pocket than an NFL quarterback. That's not really how she was viewing it. It wasn't life or death. She wasn't intending to kill him. It wasn't him or her. He wasn't coming at her with a gun and she ran him over with her car. She didn't feel her life was in danger. She simply just didn't want to get hit again. She didn't want to have a continuation of everything that was going on, and she got out of there. And it was his reckless behavior, not hers, that caused his death. And that's all he needed to say. Anyways, listen, the net result was it was not guilty. 3, whether it's an hour deliberations or 4, who really cares in the end? We got to the correct verdict. And most importantly, even with the best efforts of the judge to try to get in the way of the process of justice, it was served. A trial did happen, although I'm going to say here for the judge, I'm giving him a score of a C minus because he tried his hardest to stop the process of justice. He tried to get in the way every way he could. But what I will say is he did stop short of hindering the defendant, because there was a couple times, I didn't show the clips, where he was saying, you know, it's unfair to the defense. You're going to limit the defense's case. I can't limit the defense's case, because he knew. See, and this is why I said this guy must be a defense attorney. In my opinion, this judge didn't like the case. He didn't think this case should have been brought by the state. He knew if it was a not guilty verdict, there's no appeal. There's no reversal on appeal. However, if it's a guilty verdict and he limits the defense's case and he has them limit their witnesses and he limits the testimony or evidence on that side of any kind, it opens him up to a reversal. Hence why he seemed to be more concerned with the idea that I can't limit the defense's case, but I can limit your case. And since I think your case is garbage anyways, I don't really care, because more likely than not, it's going to result, by limiting this case, it's going to result in acquittal, and the acquittal can never be reversed. Now, again, I don't believe either side should be limited. If we're to put the process together, if we're to see justice served, you've got to have the state be able to put on their best case and the defense put on its best case, whatever that is, and ask and raise all the questions that they need to, so that when the jury's assessing the case and assessing the facts and determining whether or not the proof exists beyond a reasonable doubt that this individual that's being accused committed the crimes that they're being accused of committing, that they have all the facts and they have the best ability to do that. Only then can we say that justice was really served. But it was served in this case in terms of, I think they got it right. I think there is some improvement needed from that judge and how he conducted the trial and his fixation on getting it ended as soon as possible, even at the expense of limiting evidence, limiting testimony, and limiting the due process of the state and the defense. But anyways, that is something that somebody will, from either of those sides, will have to determine if they want to pursue. But in the future, someone in there needs to go get a contempt of court so that they can challenge this, so they can bring it to light. Because sometimes that's what you got to do to advocate. Sometimes that's what you got to do to make a difference. But this guy seems to be a little bit out of control. But anyways, guys, put in the comments what you thought about the verdict. Do you agree with it? Do you think it was the right one? I've enjoyed covering the case. Next week, we're going to get into our next case. I'm not sure what that is going to be. I know there's the RICO trial going on down in Georgia for Young Thug. I might decide to cover that. I know we've got the eyedrop Visine murder trial. It's already like 10 days in. I'm going to definitely cover the verdict. I'll probably cover the closing arguments on that. But as far as covering and tracking that trial, it's going to be a little difficult to do now that it's so far gone. And I lost a lot of ground on that because of the Adelson case. This one was perfect because it was beginning on Monday. I was able to jump right in at the beginning. But I'm going to look around. I'm going to see what's going on, see what cases are coming up, and figure out which one we're going to cover. But we're definitely going to have one to cover. I'm going to be doing continuing to do lives and coverage of true crime and trials and cases across the country. Of course, we've got several high-profile ones coming up in the near future, like Brian Kohlberger. If he goes on trial, we're going to have the Trump trials coming up potentially. We've got, potentially if the Adelson family and the other Adelson family members get arrested and get put on trial, we'll see what happens with that. So it's going to be quite interesting times, I think, as we go forward. We've got the potential for a Murdaugh retrial. We'll see how that goes. I'll be covering all that stuff. So it's going to be a lot of coverage, a lot of fun, a lot of discussions I'm going to start trying to do as the channel grows. I'm still waiting to get the live. I've got the ability to do lives on my computer, but I'm waiting to get the mobile live. So when I'm out on the road, I can go live with you, and we'll kind of have like a little mobile setup. It'll be a little bit, it won't be as like it is in studio, but we're going to make it work. And then we're going to be start trying to do some studio lives, watch some trials together. Love to get some people in the chat, because what I'm about here, it's not, I want to talk to people. I want to get your thoughts. I want to interact. I want to shoot the shit, so to speak, on these trials, man, and just talk to people about the law and about what they think. And not so much as debate, but just talk about it. And I love talking about trials. I love being involved with the trials, and discussing them and watching them and breaking them down. It's fun. And, that's what the goal is here at this channel. So I hope you're enjoying these things, these lives, or these breakdowns and analysis. More of it's coming. Hit that subscribe button, guys. And until we talk again, let justice prevail.